those who don't know me, my name is Anastasios Kamoutsas. Yes, that's a real name. They call me Stasi for short, and I have the privilege and honor to serve on this board alongside Jeff and some of the best attorneys I've ever met, young attorneys here throughout the state of Florida. So really honored to serve on this board and to introduce our moderator for the next panel, Ashley Lukis, a shareholder at GrayRobinson, their Tallahassee office. I've had the privilege of getting to know Ashley over the past year during my time at the Department of Education. Ashley actually represents the department in a bill that will probably be discussed in this next topic, which is the Fairness in Women's Sports Act. And so she is a consummate professional. She practices general civil litigation, representing both private clients and government entities at the state and local level, both at the trial and appellate courts. She also engages in eminent domain and practices administrative law, which includes rulemaking and disputes related to licensing. So without further ado, I'd like to call up Ashley Lukis, our moderator for this panel.
All right, I see my name tag over here, so I guess that's where I'll be sitting, but that was very kind, way too kind. I appreciate it. And here comes the rest of the panel to join me up here. Okay, thank you again, Stasi, and thank you, Jeff, wherever you are, for organizing such a wonderful event, and the rest of the board for organizing such a wonderful event. Before we get started, I want to introduce the other folks up here on the panel. This is Jason Zimmerman. Jason Zimmerman is a law partner of mine at GrayRobinson and a dear friend. He's a tenacious litigator. He handles everything from commercial litigation to high-stakes family law litigation, election law. He's made a few involuntary appearances on Fox News during the recount of 2018. We've also got Matt Sharp, who is kind enough to join us from Atlanta. Matt is with the Alliance Defending Freedom, which is an organization that I'm sure a lot of folks in this room have had the pleasure of working with. Matt Sharp is our constitutional law expert. He's the senior counsel with ADF and the National Director of State Government Relations. Did I get that right?
Yeah.
Okay.
Terrible title. It's terrible. I know.
Nailed it. Okay, and then joining us by Zoom, we've got Nancy Hogshead-Makar. We're so grateful that you're here, Nancy. We would have loved to have you here in person, but we're so grateful that you're still able to join us by Zoom. Nancy is a civil rights attorney. She is also the founder of Champion Women, which is an organization that advocates for equity in athletics. And she also happens to casually be an Olympic gold medalist, a swimmer. So thank you, Nancy. I'm particularly interested to hear your take on some of the Title IX issues we're going to discuss today. But I guess we thought we'd start out this morning with a really calm and non-controversial topic of the intersection of the law and LGBTQ issues. So this is a really fascinating area of the law to follow and study, particularly right now and in the last few years. From a public policy perspective, we all know that this is a conversation that dominates the airwaves, it dominates social media. But I think the purpose of the panel today is to talk about what the law has to say about some of these issues on both sides. And I know that Matt and Jason became fast friends earlier this morning, so I'm sure that by the end of this panel, we're going to have solved all the world's problems. At least that's the goal. So I guess before we jump into questions, I want to give just a quick overview of why this is such an interesting area of the law right now and what has been happening in the last few years that makes this topic so timely. So rewind back to 2020, I'm sure a lot of us are familiar with the Bostock decision that came out of the Supreme Court, the United States Supreme Court. And that was a Title VII case, so an employment discrimination case that found that discrimination on the basis of gender identity and sexual orientation constitutes discrimination on the basis of sex under Title VII. So that's a groundbreaking decision. And since then, in our very own 11th Circuit, we've seen the Adams case that's currently pending before an en banc 11th Circuit that has to do with sex-segregated bathroom policies at a public school board here in Florida, and the application of that policy, specifically the way that the school determines a student's sex. We've also, as Stassi mentioned, in the Southern District of Florida, we've got pending a challenge to the Fairness in Women's Sports Act, which was passed by the Florida legislature in 2021. We've also, of course, as recently as last week, seen the Biden administration's voluminous proposed changes to the Title IX regulations. So this is an incredibly interesting area the law to be following. All of these variations of these different issues sort of manifest themselves in different ways depending on the legal framework that we're talking about, whether it's Title IX or Equal Protection Clause. We're going to talk about all of that. But first, just to break the ice, I thought we would talk about House Bill 1557, which is the Parental Rights and Education Act that was passed by the Florida legislature this year. And for those of you who are not with me yet, this is the bill that has been uncharitably and inaccurately described as the Don't Say Gay bill. It is currently the subject of a legal challenge in the Northern District of Florida. And what sets this case apart from some of the other cases we're going to talk about is that it has a significant First Amendment challenge that comes along with it. And so, Matt, obviously the place to start on that is with you. I'm curious to hear your take on the merits of the First Amendment challenge in that case, and particularly given the nuance in First Amendment law when it comes to government speech by government employees, teachers in the classroom.
Yeah, well, thank you so much for having me. And Jason and I actually had some really fun conversation. And so HB 1557, when you really look at it, despite all of its misbranding and things like that that the media has done, is really focused on giving parents more authority and control over when their child is exposed to certain issues. And specifically, the issue that has been the focus of a lot of attention and the litigation has been over the provision that says when it comes to discussions and instruction, specifically, instruction on sexual orientation and gender identity, we're not going to do that in kindergarten through third grade. And then after that, we're going to do it in a way that's age appropriate. And unfortunately, that has now been challenged in court on a variety of grounds. One of them is on vagueness. Others have been on equal protection grounds and some other aspects of the law. One of the things I do want to point out, there are some other really important protections in the law that haven't gotten as much, specifically when it comes to the right of parents to know what's going on to their child's mental, physical, emotional health that's happening at schools. Our firm, we've been involved in, unfortunately, several cases where parents have been left out of the loop as their child was dealing with gender dysphoria. And when you talk to medical experts about this, when you talk to psychologists, they say if a child is struggling with any issue, whether it's eating disorder, depression, anxiety, or gender dysphoria, you want everybody in the loop, especially the parents. You want that 360-degree care. And so all the state of Florida was trying to do is to make sure that parents are in the loop on this. But turning to the specific provisions of the instructions in sexual orientation and gender identity. So the vagueness challenge is basically, what does this mean? Teachers aren't going to know what they are and aren't allowed to do in the classroom. And I do think that it's a weak claim, because there's a lot of instances where the state sets instructional guidelines and says, schools, this is what you should provide instruction on. You probably read through Florida Education Code, you're going to see things on history and math and science and other things, where the state just says, we want you to provide instruction on this, and then thereafter the Department of Education or local schools then flesh out what that means. And that's all Florida was doing here, is we're saying we don't want instruction on these topics until a later grade, and then at that point when it's age appropriate. So I think on a First Amendment ground, there's really no issue here. This is government speech. The government obviously has clear authority to determine what is taught in schools, when it's taught in schools, and then to provide leeway to state regulatory agencies, local schools to do that. I don't know if you want to get into the equal protection or you want to save that for later.
By all means.
Okay. The other argument in case that I do think is actually an interesting theory is that this law violates equal protection by discriminating against LGBT students, teachers, etc. And so the lawsuit was actually filed by families, by teachers, and others. And to me, when I'm reading through this, the claim is essentially, you're not teaching this at certain grade levels, and that's creating discrimination against us and pointing to some statements by some legislators that maybe didn't word things as artfully as they should have. But to say that the failure of the government to teach a topic in certain grades violates equal protection is discrimination. And I think it's a very novel claim, is the idea that if you don't teach what we want, you're discriminating against us. So let me put the hypothetical into different terms. Let's say the state of Florida said, we don't want to teach world religions from kindergarten through third grade. Let's save those for older grade levels. Religion is obviously a sensitive issue. We're going to leave that to families. So all we're saying is we're not going to provide instruction. Again, instruction. We're not talking about discussion. We're obviously not talking about students' free speech rights, which our firm has vigorously protected, nor are we talking about casual teacher interactions. Instruction. Would a Christian, Jew, Muslim say, you have violated equal discrimination, you have equal protection, you have discriminated because you are not mandating instruction on world religion in K through third grade? No, we would recognize that's the prerogative of the state to do that, and that doesn't create an equal protection violation for the state to say, we don't want to speak on this subject right now. And so I do think there are some very novel claims here, but ones that, if that was the case, what else could be mandated to be instructed under the Equal Protection Clause?
So I think you brought up an interesting point that in many of the equal protection cases that we're seeing in this area, the line drawing or the classification that a law or a policy is drawing is much more easily discernible than in the case of House Bill 1557. A perfect example of that is Adams, sex-segregated bathrooms. Even though I guess the most recent panel decision said we're not ruling on whether or not sex-segregated bathroom policies are constitutional or not. We'll see if the en banc court has something to say about that. But that, and in the sports context, the line drawing is a little bit more easily discernible. Now, Bostock was not an equal protection case, so I think there's still a lot of room for courts to tell us how these issues shake out and whether sexual orientation and gender identity constitute sex discrimination on those bases, or differential treatment on those bases constitutes differential treatment on the basis of sex under the Equal Protection Clause. And Jason, I'm curious to hear your thoughts on do you think that the analysis that the court applied at Bostock should also apply in the equal protection context to determine if discrimination on those bases falls under the prohibition against sex discrimination?
Well, I think it does, and I want to say thank you for having me here today. It's really a privilege to be up here with Matt and Ashley, that I've known for almost a decade now. And just so the back and forth doesn't get confusing, I'm the liberal and arguing the liberal position here. So I really do appreciate having the opportunity to speak with all of you. And I really appreciate Judge Meisel's comments that the Federalist Society is really a debate society. It's the free exchange of ideas. And I don't expect any of you to agree with my position. I don't necessarily endorse all these positions. These are the liberal positions. In fact, the DNC is right across the street. I went and picked up the notebook from the DNC and Nancy Pelosi. So I'm ready to go. I do want to say, I think Bostock did talk about equal protection. It didn't hold. And Justice Gorsuch, who I believe is also a Federal Society member, found that you cannot make policy or regulations or do something solely on the basis of gender identification and sexual orientation without it being related to sex. I mean, not to be very basic, but sexual orientation, the word sex is right in there. You can't separate the two concepts. And I think Matt and I agree that gender and sex are two different constructs. There's difference between gender and sex. However, where I think we diverge is we believe on our side, the liberal side, and question whether or not, there's some interchange between sex and gender. You cannot have a gender discussion. You cannot have a gender policy. You cannot have a gender regulation without it also being about sex. Those two things have to be considered together. And what Bostock did and what Justice Gorsuch did was not go to the issue of whether or not gender identification and sexual orientation is actually in Title VII. What they found is you cannot address gender identification or sexual orientation. You cannot do something because of that without it also being related to sex. And I think that feeds into all what we're talking about. I think it also includes talking about House Bill 1557. I think it's going to be an issue with Adams. The issue has been left unresolved, but I don't think we need more clarity. I know it's hard to suggest that. Justice Gorsuch started the Bostock opinion with a great quote. He says, "Sometimes small gestures can have unexpected consequences." The more regulation we have, the more opinions we have, the more clarity we think we're developing, the farther we get from actual clarity. That's our, the liberal position's biggest issue with House Bill 1557, which Matt was talking about, the whole vagueness issue. What are we actually doing as a state? What are we actually regulating, and why? Why are we doing this? The idea is, as Matt said, to give parents right to control their kids' education, be involved. I think both sides agree with that. And as Matt and I talked for an hour and a half, and we came to agreement on most issues. There is an element of compromise here. I think both liberals and conservatives, Democrats, Republicans, every side agree that parents should be involved in the control of their kids' education. In fact, we want that. It seems like a great idea. But the question is, and what Equality Florida in their lawsuit is challenging, is does this bill actually do that? Does the statute, as well written and well intentioned as it is, does it actually accomplish that goal, or does it create unexpected circumstances and unexpected consequences? That's the concern the left would have with this type of bill, this Don't Say Gay bill, which Ashley said was inaccurate. The problem is that there are certain people in our state, certain kids, certain teachers and professionals that think that that's what this bill does. And that's a problem. And that's the reason why I'm not exactly sure we need further guidance on equal protection. I don't think we need the Supreme Court to extend the Bostock decision further. We've seen with Adams, which we'll talk about later, that you can link gender identification and sexual orientation to sex. Justice Gorsuch in the Supreme Court has already done that. There's no further work needed. It doesn't add any protections to have anything more specific or more on point. We have a Supreme Court that has said, in a 63 decision, which, if anyone recalls during that time, came as a complete shock to our side. The left was expecting it to go the other way, 5-4, maybe 6-3 against it, because the arguments that were raised by Justice Alito in his dissent were the arguments that we were seeing over and over again. So it was a complete shock. And now we're in a situation where the Secretary of Education has just entered new regulations that support the Bostock link between gender identification, sexual orientation, and sex, and provides protection to students and teachers and faculty at public institutions. So I don't necessarily know we need more than what we already have. It didn't reach the question of whether or not specifically it's part of equal protection, but it gave the argument enough and gave it enough foundation that we don't need to do anything more, bring any more cases to secure that right for the individuals.
Nancy, I see you furiously taking notes.
We're just curious.
Jump in and read us what you've written.
No, it wasn't so much notes, but here's the thing. What Bostock did is it made gender identity and sex discrimination the same thing. So, and that, for the most part of life, that is absolutely appropriate if you're talking about employment or being in the classroom or public accommodations, et cetera, et cetera. But there are some places where those two things need to be disaggregated. And there are some things where, trans rights are human rights, but women's rights are human rights. And sometimes that two things clash. And I think we're going to talk about that just a little bit later.
So I think the point that you raised is one that, Jason, you mentioned earlier as well, and that is that typically we're acknowledging that sex and gender identity, or sex and gender rather, are two different things. And I think that's important in the Title IX context in particular, which we'll talk about in a bit. But I don't know that at least the most recent panel opinion that came out in the Adams case is not so clear on the distinction between those two concepts. And so and I really open this to anyone who wants to jump in on whether you think we're going to see a trend towards kind of conflating those two terms in judicial opinions, or if they're going to stay separated.
Yeah, so I'll quickly. I do worry about the conflating of the terms. So one is just a pure textualist matter. If sex does no longer mean sex, but it now encompasses all of these things, I mean, how many laws? I mean, every state has laws that provide different programs and regulation based on sex. Everything from obviously employment and public accommodation and things like that to programs dealing with, like minority-owned business loans. And so if you have a preference for members of one sex being access to government loans, does that now open it up to anyone of that gender identity now has access to those? And so there's so much of society that is built upon recognizing the differences, a recognition that even the late Justice Ginsburg acknowledged in the VMI case. This was, again, the woman wanting access to the Virginia Military Institute. And although she ruled, yes, you must allow her to enroll, that doesn't mean that we don't have separate dormitories and housing or even the physical standards, because Justice Ginsburg recognized that there's differences. And so I very much worry about when I see cases like Adams and others that are conflating the two, or they're saying, well, they're interchangeable, or if we ban sex discrimination, shouldn't we also do that? Entirely separate questions, entirely separate issues involved. And I do worry about courts taking that authority. This is where in Bostock, I think it was Justice Alito pointed out that Judge Posner in the Seventh Circuit was at least honest when he did this and say, hey, Posner admitted, you know what, I'm rewriting what sex means. That's what we're doing. We think this is better policy. And at least he was honest about it. I do worry about this subtle conflation of the two, that we're really eroding the understanding of sex and the long-term consequences that's going to have in a variety of areas.
I actually agree with Matt when I do worry about conflating the two issues. I have different reasons why I agree with Matt, but I think gender and sex should be two separate constructs. I just agree with Justice Gorsuch that you cannot have gender discrimination without it also being because of sex. You don't need to create more protection. You don't need to create more regulation. If you conflate gender and sex, you're creating more problems. And I also think practically the liberals would lose 2 justices on the Supreme Court if they conflate gender and sex. I would prefer Adams goes what Justice Gorsuch did. Don't conflate the two. Be fine with acknowledging that there's a difference between sex and gender. Just be also fine with acknowledging you can't discriminate on either.
So setting aside the draft, 700 pages of preamble and draft regulations that dropped a week or two ago, I think that one place that this issue could play out with real consequences is in existing Title IX regulations. And so, Nancy, one question I have for you is in the sports context. So we've talked about the Fairness in Women's Sports Act, limiting participation in women's sports to biological females. There are Title IX regulations that have been in place for a very long time that say that's perfectly fine. There's an exception from the blanket prohibition on differential treatment on the basis of sex for sports teams. So really, states like Florida are just doing what the existing Title IX regulations already allow. So from your perspective, Nancy, why does that not end the question if sex is something different than gender?
Right, because what the worry is that it will be ubiquitous, that gender identity discrimination will sort of swallow up sex discrimination. So back in, as you know, Title IX passed in 1972, and it was based on Title VI. Title VI bars discrimination based on race, color, national origin. That was part of the big civil rights package that had to do with banking and public accommodations and voting and everything else. And it was a way to make sure that the separate but equal of the Supreme Court decision dealing with schools also applied to private schools. Okay, so schools could not discriminate based on race, color, national origin if they received federal funds. And so when Title IX was passed, it's just essentially the same law, but it just took out those words and put in the word sex. And then in 1975, the regulations came out dealing specifically with sport, and they recognized separate but equal. So so I was with the Women's Sports Foundation for 30 years. And in those 30 years, the most popular white paper that was downloaded over and over again was the one about sex segregation. And, why do we have formal sex segregation in sport that we don't have in the classroom or in all these other places? Like, why is it okay here but not in these other places? And the answer is, I've been saying the same thing literally for the last 30 years, is if you want to give girls and women an equal opportunity in sports, they need to have their own team. And sort of nothing's different. I would add that the way sport accomplishes diversity and inclusion is they create categories. If you don't have categories, then men the ages of 20 to 33 would win virtually everything. Then you wouldn't have any opportunities for people with abilities. You would have 25-year-olds competing against high school students. You wouldn't have any weight categories. In wrestling, the weight categories start, I think, for men at like 109 pounds. And the 109 pounder would not have opportunities. So the way you get diversity is by creating categories. And if you have categories, then they have to have parameters. They need to have meaning around them. And so the concern is sort of twofold. First is the concern is that if gender identity and sex discrimination are the same thing, then somebody who identifies as being a woman would be able to compete much like Leah Thomas. Leah Thomas at least was taking testosterone reduction and sort of complied with the NCAA rules. So imagine somebody not having to go through that and be able to compete in the girls and women's categories. This is all against a backdrop of women being discriminated in athletics in the most profound ways. It is because it is sex segregated. Everybody in the whole school, whether you're interested in music or dance or debate or physics or whatever you're interested in, people can see how the school treats men and women when they do sex segregate. And right now, women are if men and women had equal opportunities to participate, they would have almost 200,000 more women would have almost 200,000 more opportunities to participate, number one. Number two is they would have $1.2 billion more in college scholarship dollars. That is huge what it means. I mean, 100 years ago, our country did something that was really great, that other countries are very jealous of us, which is we merged our sports system and our education system together. And that turned out to be a very smart call to do that, because what we've learned is that sport actually makes smarter kids, that they're more likely to graduate from high school, go on to college, major in STEM. They make 6% more for the rest of their life. Great research, Betsy Stevenson showed that it wasn't just that kids who were going to do well anyway, who went into sports, and that was the reason. Maybe it's just an association, it's not causation. Betsy Stevenson was able to show that sports caused all these really great things. So when we're denying women 200,000 college opportunities or 1.3 million opportunities in high school, you're denying them a type of educational experience that is irreplaceable. When looking at other after-school activities like the debate team or being involved in the student newspaper or student government, it did not have this big gap. It did not show the boost that participating in sports produces. And then you have the lifelong health consequences as well. So we did something that was really smart. And then over the years, the past 50 years, I frankly have been spending too much of my professional life making sure that girls and women had the right to equal opportunity, but not actually making sure that it was happening on the ground. So my organization, Champion Women, we are funded a lot by men with daughters. Men with daughters, most of them got to participate in sports when they were in high school and college. And so they recognize what an important educational opportunity that this is. So bad outcome number one is just that anybody, would be able to participate on a girls' team, taking away something from girls when they're already fantastically behind where the men are. Okay, so that's bad outcome number one. Bad outcome number two is that if we don't sex segregate, we formally sex segregate. If we don't do that based on biology, then people hostile to women in sports and all the rights that women have in sports would be able to strike it down, to say that it's not, if it's not based on biology, like what, we could blow up the whole category and say, you know, schools can keep their girls and women's team, but women would not have the right to equality. And I do have to say, Champion Women are members of the Women's Sports Policy Working Group. And we're working very hard. It's really a two-step process. The first step is, how do we create boundaries, as Florida has done, around the girls and women's category? Then the second step is that Florida needs to do, and all these other states as well, is, okay, well, how do you include, right? Leah Thomas really has gone through gender affirming hormones for, I think, 2.5 years now. And so again, sport creates inclusion with different categories. So we're looking at, it's going to be very different for different sports on how it is that people include.
You've done an incredibly compelling job of describing exactly why the state interest is so critical in cases like this. And I obviously think it's very easy to see why, particularly in the sports context, it really stands alone in terms of separating based on biology. I want to talk about the same sort of analysis you just went through on the sex-segregated bathroom side, because I think the conversation is a little bit different and maybe tougher. We'll find out. But before we do that, now Jason's the one furiously scribbling. So what have you furiously scribbled?
I wasn't furiously scribbling. Surprisingly, while I respect and don't really disagree with the merits of creating equality for women in sports and women in the education field, and specifically sports in the education field, is a lofty goal and one that's noble, and we should keep on pursuing it. My problem and the left's problem, and really the far less problem with this, is this really a problem that needs a solution? Leah Thomas is a poster child for this issue. As Nancy mentioned, Leah has been doing gender-affirming therapy since 2019. She complied with all the NCAA regulations. She complied with all the regulations that would have been in time for either the United States Olympic Committee on Swimming or the International Olympic Committee. Leah Thomas did not win every event she was in. Leah Thomas came 5th in the 200 meters, became 8th in the 800 meters. Leah Thomas would not have made the U.S. Olympic team as a female swimmer. So this is to many of people on my side of the aisle, a problem that doesn't exist, and rather a government trying to legislate behavior when it really doesn't need to. I wanted to prepare for this because Matt and Nancy do this for a living, and they're very, very good at what they do. I reviewed some of what Matt has done, and he's been involved in these issues. And in South Dakota, they passed a similar bill, Fairness in Women Act, and the South Dakota Athletic Association presented evidence that said, since South Dakota has allowed transgender women to compete in male sports for 5 years, one case. So we're passing legislation. We're having a national conversation for South Dakota's one case, for Leah Thomas, for a small portion of a small portion of a small portion. So where I think there's a compromise, and where I think that a lot of both sides would agree, is, yes, we want equality. We don't want someone to change the playing field. We don't want someone to upend the playing field. But are we really going to pass legislation telling transgender individuals who have a deeply held belief of their gender dysphoria, that a biological male believes with all of his might that he is a her? Are we really going to tell them that you cannot compete in a sport matching your gender? To many on my side of the aisle, it's a bridge too far. It is a small gesture that would have unintended consequences. And it's something that we as a society need to think long and hard about if we're willing to take that step. But as Nancy's raising her hand, she's going to yell at me probably. What I'm proposing, what the left is proposing, doesn't solve the problems Nancy has rightfully outlined. It doesn't solve the equality issue. It doesn't solve the women's, the fact that, when Title IX was passed, women's sport, there was 300,000 women competing in college athletics. Since Title IX, that number has gone up by 6 times. There's now more than 1.8 million women competing in college sports. So we're doing better, but we're not done. And there is no doubt that allowing transgender individuals to compete across biological spectrums is going to impact that. My side of the aisle, and I believe the more common ground, is if it's not a real problem, it's not a major problem or a significant problem, let's take them as we go and not create legislation that are telling individuals that are being discriminated against currently that they can't compete in their gender-specific sport. It's just an unnecessary step.
I'm hearing a lot of policy argument, and what I really want to hear is, what does the law have to say about this? What does Equal Protection Clause have to say about this? And what does Title IX have to say about this?
Can I say one sentence? I'll throw it to Matt.
Well, right, the rules of presidential debate. You mentioned Matt's name. He get a
right,
chance to respond, but yes.
So what does the law say? I'm going to rely on what Justice Gorsuch said in Bostock. You cannot discriminate based on gender identification, and saying a trans woman cannot compete in a male sport would be discrimination.
So real quick, I want to go back to the first thing, that there's no harm. I would obviously dispute that because we represent a handful of girls from Connecticut where, because of Connecticut's policy, 2 biological males that identified as female were allowed to compete, and within just a couple of years captured 15 championships, broke 16 records that had been held by almost as many girls, and over 80 instances where girls in Connecticut and throughout New England lost opportunities to get a spot on the podium or even advance in competition because of 2 males. And I think, as I shared this line with Jason earlier, but we install sprinklers before there's a fire. And so when states like Florida and South Dakota and others are looking at what happens in Connecticut and say, we don't want girls to lose those opportunities. But even likewise, there's also a lot of issues with what do they do to those championships won by those 2 males? Do they strip them away? Do they yank those medals? Do they reinsert that? It creates a lot of chaos. And so I think it's appropriate for states to step in and say, we want to avoid that chaos. We want to ensure equal opportunities. Now, to go to the legal question, these laws do not discriminate based on gender identity. Take 3 males that all want to compete on the female team. One of the males identifies as male, one of them identifies as female, one of them identifies as non-binary. Under any of these laws, including Florida's laws, their gender identity is irrelevant. Florida does not care how any student identifies in any regard. All they say is, are you biologically female? If so, then you are now eligible to compete on these teams. These are just simply eligibility rules. No different than weight eligibility that we have in many wrestling categories. No different than age categories that we have that says the college freshman can't go back and play on the junior varsity team because that's unfair. We even have geographic rules that prevent, if you live in a certain district, you can't be recruited to compete in another district. And so these are just one of many eligibility rules that have nothing to do with gender identity, but rather recognize that because of the physiological differences, as Nancy said, the best way to have diversity is to have sex-specific categories.
Can I jump in?
Yeah, of course.
Okay. Yeah, I really found, so Jeff and I are fellow liberals. I am a lifelong Democrat. I actually got to introduce Nancy Reagan in the Republican convention because I was still mad at Jimmy Carter for keeping us out of the Olympics in 1980. I actually moved away from home when I was 15 to train for 2.5 years for the 1980 Olympics. So Jeff says 2 things that I hear frequently. One is it's just not a problem. And then when it is a problem, then it says, is it really such a big deal? And that is profoundly sexist because what you're saying is women's sports don't matter. It's okay for somebody to come in, for Leah Thomas to be able to come in and be able to compete. And you said something that also is like, hair on the back of my neck. because what you said is Leah Thomas didn't win everything. Okay, Leah Thomas went from when Leah was competing as a male, not being able to qualify for the NCAA championships, not being in that category. I have to tell you, as an elite athlete, somebody who was ranked, in the top few for 8 years, I was on the U.S. national team for 8 years, that somebody who's ranked, I would say 15th, I didn't know who they were. I didn't know, their name or whatnot, unless like they were on my team or something like that. And so to go from not being able to qualify to getting first, fifth, and eighth, there are 13,000 women competing in the NCAA in swimming. 13,000. To say that like she didn't win everything is just, it's inaccurate. And it doesn't portray the, suddenly now being able to be in the finals in 3 different events. She was just nominated to be the NCAA's Woman of the Year. Again, we have categories for biological reasons. If anybody's interested in the science of men versus women, I encourage you to go on to, there's a website called Icons Women. And the second day, they have outstanding medical presentations by some of the best researchers in the world that look at what hormone replacement does to a body, and what the International Federation for Swimming, FINA, has done, and what United States Swimming has done is they have now instituted rules that say that if somebody has male puberty advantage, if they have essentially what male puberty gives somebody, they cannot participate in the women's category. So because we know that that testosterone reduction just doesn't take away very much. It feels like a lot to that person because it's like 3%, but the gap between men and women is like 10%. And so and when it comes to say like weightlifting or something, it's a whopping 30% gap. So we have sport categories because of biology. And if the science says, we all are lawyers, we depend on what our experts say, and the experts say unequivocally that you cannot roll back male puberty in a way that makes it fair for the women who are in that category. So, number one, we know because of the people that are identifying as gender, that the number of people who are going to be coming into sport are growing. And it's better to get it at the front end rather than having it be, as you said, Jeff, it's not about Leah Thomas. It's not about any runners who are in Connecticut. It's not about them. It's about the principle of having a women's category that is for women.
So I see Jeff walking around, but I think we still have some time left. Before one thing I really do want to touch on, because I think we could talk about the sports issue all day. It's fascinating. I love it. I'm lucky enough to be involved in a case about the bill. It's incredibly interesting, but this incredibly compelling state interest that we're talking about, and that's how I'm thinking about it, is the state interest in this type of regulation and its legitimacy. That conversation is different in a case like Adams, which involves sex-segregated bathroom policies. So I want to touch on what that analysis might look like in that context, since the interests are a little bit different.
Yeah. So, and Adams is an interesting case because we're still waiting on an en banc opinion. We've had 2 kind of intro opinions. One was vacated, one's en banc. And Matt and I have had a lot of discussions on this, and we actually agree regarding student privacy. Once again, we just diverge on what that actually means. And to many on the left, and a little bit of my own personal beliefs, the state interest here is in protecting all of its students, including its transgender students. And until the empirical data says otherwise, most of these transgender segregated bathroom cases have amici brief that talk about these studies. There's been surveys, national youth, that talk about who actually is impacted by these segregated bathroom cases. Are people actually being assaulted, harassed, if you allow transgender gender individuals to go to an opposite of the biological sex? The answer is unequivocally no. Yeah, we've all heard anecdotal stories, and it feels like there would be a privacy issue or a privacy concern. But there is empirical data. 17 states currently require no discrimination based on your transgender status. In those 17 states, there is not an increase in sexual assault or harassment related to bathroom-related incidents. There's no significant difference between those 17 states and the other 33 states. Likewise, there's 200 municipalities and localities in the United States that have anti-discrimination bathroom-related bills. There is no statistical difference between those 200 municipalities and any other municipality in the United States. That's what the empirical data showed. That's what was presented at the Adams case. The school board, which was trying to come up with a reasonable accommodation, some sort of way to not endanger or discriminate against the transgender individuals, but also provide and protect the student privacy that Matt champions every day, and he does it so nobly. Is there some reasonable accommodation? But the school board, and all this time at trial and all the work they did, could not find any empirical data that says that the student privacy concern that Matt protects and Matt rightfully champions is an actual issue. So because of that, there isn't a real significant government interest. There's one anecdotally. There's one that we all kind of believe in our heart should be there. It should be awkward for have someone of a different gender in your bathroom stall, or someone of have different sexual organs in your bathroom. But that problem isn't occurring. And until such time as there's data that says it, there is no significant government interest to protect this. At least that's what the argument on the left says.
So I'll respond, and Jason's right. I mean, there is common ground, and when you read Adams itself, a recognition that there is an interest in privacy, that a young woman has a right when she's changing and performing these intimate activities not to be viewed in a state of undress by a member of the opposite sex. So I think a couple things. Number one, we've got to start with the law. And what does Title IX actually say? When it bans sex discrimination, it nonetheless, in both the law itself, but it's in enacting regulations, that schools can maintain separate facilities on the basis of sex, including dormitories, locker rooms, and yes, restrooms. So question number one is, does the policy at issue in Adams, is it consistent with Title IX? 100% yes. And so to some extent, I would say to those on the left, if you want California and Massachusetts to be able to have laws that do this, can Florida also have a law the other way? And unfortunately, those in Adams challenging St. John County's policy are saying, no, you can't do that. That is discriminatory to do that. And so as a just purely legal matter, Title IX says schools can do this. Why can't Florida do it? So then I think we get into maybe some of the slippery slope arguments. If we accept their thing of, well, bathrooms, there's not that big of a deal. Your privacy and students are fine with it. Well, then it opens the door, because if you're now saying we're going to let the male that identifies as a female use the female restroom, how does that go into locker rooms? Well, Adams dodges this, and this has popped up in a lot of litigation. We're not talking about locker rooms. We're not talking about locker rooms. But the interests are largely the same. The same arguments can be made. Well, we can give you a private place to change if you're uncomfortable with that. And then it goes into, how about overnight school trips? Well, now you've got to force a girl to share a bed in a hotel room with a biological male. This has happened. We've unfortunately had parents reach out to us in some states that the schools are saying, yep, we've got to allow it, and you don't have a right to not share a bed with someone of the opposite sex, because otherwise. And then we get into sports and all of these other things. And so I think as a purely legal matter, we want to go back to, there's a government interest in protecting privacy, and the state can look at this and say, the best way we can do this is to maintain these separate facilities on the basis of sex. While, and I think this is, again, where Jason and I would find some common ground, should we accommodate, should we provide compassionate accommodations to transgender students? 100%. I think there ought to be numerous single-user facilities that not only transgender students, but any student with privacy concerns. You know, someone that maybe they've got a medical condition that they don't feel comfortable using a communal restroom. I think those ought to be available, and I recognize that not all schools have those. I think that's a good place for the government to put its dollars. Provide more of those while still saying, but that doesn't mean we have to blow up the idea of sex-specific facilities.
Well, this agreement is just a beautiful thing to watch. Judge Mizell, I hope that we're making you very proud with this respectful debate. So I do want to leave some time for questions. But before we do that, because it's hot off the press, Matt, Nancy, Jason, one of you want to give a 2-minute elevator speech on the key points of the proposed Title IX regulations that have just been released.
I nominate.
Everyone's looking at you, Matt.
So so again, I love Jason. He had the quote from Bostock. It's like the little things can have big consequences. Bostock led to this 750 plus page monstrosity of a regulation.
Good.
So here's the language I want to highlight. Buried, I think it's in like page 500 or something like that terrifies me. So it's taking Bostock and again quoting directly from it that an action taken on the basis of sex includes gender identity. And here's what it says: when a person is denied access to education programs or activities consistent with their gender identity, it causes them more than de minimis harm on the basis of sex. Therefore, such treatment generally violates Title IX's prohibition on discrimination to the extent it causes more than de minimis harm. You talk about erasing the ability of schools and programs in any method, locker rooms, restrooms, sports, whatever it may be, single-sex institutions themselves, to be able to exist. This is what that's leading towards. Now, I know if you read through it, they say, well, we're not going to specifically address sports and all of this other stuff. But the principle the Biden administration is pushing is that in any way, when it comes to pronoun usage, does this now mean that not only can you mandate that teachers, but even other students, are you creating a sexually hostile, a gender identity hostile environment if another student says, I don't feel comfortable using your preferred pronouns? So we're getting not even just into the privacy or the equity and fairness in sports, but into matters of speech, matters of religion, and things like that are implicated by this very broad, far-reaching re-understanding of Title IX.
Can I give a 15-second elevator speech on?
Of course you can.
So what the DOE regulation was meant to do is recognize that there are individuals in our communities and individuals in our schools who are currently being harassed and discriminated against because of their gender identity. The recent study done, the empirical data shows that people who are transgender suffer bullying incidents 4 times more likely than the average student. That in the cases of depression, it's 6 times more likely. And a suicide rate is double. So what the DOE regulation does, it's not perfect, and it's 700 pages based off one line, and I'm sure there's going to be a great many unintended consequences from this regulation. I'm sure Matt and his team and Nancy and her team are going to be on the forefront of adapting and trying to argue and make this regulation work. But the bare minimum of what it does, and the reason why I think it's a great step forward, and the reason why I think Bostock was a great decision, was it's addressing a current problem regarding discrimination against transgender and based on your sexual orientation in our high schools and in our middle schools. And if we can do something to help those children, we should do it. We should do whatever we can to do it. However, nothing's perfect, and we have to be willing to compromise. We have to be willing to realize that this regulation shouldn't go to same-sex institutions. We shouldn't ban same-sex institutions, though, and if it starts going that way, I might move over to Matt's side.
Well, we don't have enough time to talk about the correlation versus causation issues with the statistics that you brought up, but
I hate my statistics.
I guess now we've got a little less than 20 minutes left. Do we want to maybe open the floor to questions? I know that there's probably a lot on your mind. Or not. Does anyone have? Oh, come on up.
Okay.
Don't be shy.
Is this on? Okay, perfect. Matt Covert, Regent University School of Law. Just a very general policy question. How do we future-proof our arguments as the technology changes with transgender surgery, as it gets more advanced? How do we kind of keep our arguments both specific but broad enough to cover advances in technology when it comes to gender reassignment surgery?
Nancy, do you want to take that one?
I'm actually not sure what you're getting at. There is gender reassignment surgery. again, I'm here as your resident expert on how these things relate to sport. The interests of bathrooms and privacy are very different from, say, sport or single-sex prisons, or the right to be able to have single-sex rape crisis centers, et cetera. Those are all very different, bring up different issues. I'm not sure what you're getting at. You want to explain a bit more?
I'll take a stab at the defeatist approach, and maybe Matt will have a more optimistic approach, but you can't. You can do what you can try, but even with the construct that Bostock had and what Adams is wrestling with, as technology increases, as gender appropriation therapies are better, or get more intense, or get easier to accomplish, the arguments are going to have to change. I mean, they're necessarily going to have to change. And I know that the Federalist Society, as Judge Mizell talked about, were originalists, looking at the wording of the statute and the law at the time it was done, so that we know it was directed toward an audience that would know what the words meant. Unfortunately, with technology, that's not always going to be the case. So you can't future-proof your arguments. What you have to do is, just like being the originalist looking at the statute at the time, you got to make your arguments that are currently you have to know that Bostock's the law of the land right now. There are states that have already distinguished Bostock. The Iowa Supreme Court, I think 2 months ago, just said Bostock doesn't apply to our state statutes. Even though our statutes are literally the same, we don't have to follow the Bostock reason, and we don't agree with it. There have been a couple cases that have declined to extend Bostock on that ground. So I don't think you can future-proof your argument. And I don't think you should really be focused on trying to future-proof it. I think you should be focused on looking at the time, what the law is right now. And if you're in favor, if you're on my side of the aisle and like this, and you want to find cases that support it. If you're on the other side and want to challenge it, use cases like the Iowa Supreme Court case that show the holes in the analysis. Don't try to say, how do I make sure that this brief I write and this order that I'm going to draft will stand the test of time? Because it's just not.
So I will disagree with Jason on this, unsurprisingly. I think terminology matters. And I think this is why a lot of the fight post-Bostock has been to properly recapture and preserve what sex means. That we're not talking about an internal sense, nor are we even talking about testosterone levels or things like that. Sex always has and should continue to mean the distinctions between male and female, primarily chromosomal, that no amount of surgery, no amount of therapy changes the fact that there's XX and there's XY. And I get, and Jason and we were talking about this, are there individuals with intersex? Absolutely. They are, number one, protected under the Americans with Disabilities Act, so there's already protections there, and I think those should be fully afforded. But the fact that there's individuals that are born with a disorder of sexual development, where somewhere along the process something went wrong, does not disprove the fact that there are two and only two sexes, and that we can preserve and write that into law. The second thing that concerns me is we're seeing more and more studies coming out about the harms of these gender identity procedures in kids, the puberty blockers, the cross-sex hormones, and the surgery. At the same time that in many ways the Biden administration and some in America seem to be running towards those and saying, yes, every kid should get that. Let's immediately put them on puberty blockers. The rest of the world is looking at this and saying, this is really bad medicine, that we're out of, Sweden, 19 times higher rates of suicide of individuals that went through full gender transition in a culture that is very accepting of it, and yet they still had these higher rates. And so we're seeing Sweden, England, New Zealand, all of these other countries saying, we're going to reverse course and discourage kids from going that because it's untested, it's experimental, it's harmful. So I think the two responses to your answer, number one, we've got to preserve a proper meaning of sex. It is biologically based, it is not changeable. And number two, I think we ought to policy-wise say, should we be putting some protections in there about some of these unknown things when it comes to procedures and things like that, especially as it relates to minors. I think that's one of the things that's been very encouraging to see Florida take the lead on that. The Department of Health issued some guidance a month or so ago saying, look, based on the coming evidence, we're going to discourage this and say this maybe is not in the best interest of kids to let them undergo some of those experimental procedures.
And the problem with Matt's argument, and as to point one, if you try to future-proof your argument because everyone agrees with keep the definition of sex the same, you've already lost. Because Bostock's told you we're talking about another construct, gender, which has nothing to do with what the binary form of sex is, but because gender identity is related to sex, we have to talk about gender identity and say it's discriminatory if you do something based on your gender identification. So if you focus on sex, like it's a separate argument. You can't future-proof your argument by saying we're going to keep the definition of sex the same. That does nothing for your brief with the current law of the land. The current law of the land in most states and under federal law is that gender is separate from sex. So it doesn't matter how you define sex. Gender identification is different. And because gender identification is different, it has absolutely no bearing on your argument if there's 2, 5, or 15 different sexes. So that's the reason I would disagree with that. Your focus is on the wrong point. If you're on the other side, you need to focus on how do you get gender identification out of the textual reading of Title VII, because that's where I think Justice Gorsuch really did our side a favor by reading that in and showing that there was some connection between gender identification and sex.
Reading it in says a lot. Great question. Does anybody else have a question? Sure. Oh.
Hi, it's really been enjoyable. I have 2 questions and a brief, reaction. I think it's indisputable that there is obviously empirical data on the side of there is a social problem with transgender kids in particular in school. It's a very terrible setting. But assuming your position that there's absolutely none on the other side, right? Assuming that, the question is always, is the medicine too much or worse than the disease, right? It strikes me that the range of the rawest emotional range here is between looking at these regulations or outright prohibitions as approaching or being more similar to weight and age restrictions in sports and having some sort of rational basis versus the broadest of them and the least nuanced of them striking us as race-based eligibility restrictions from, back from Jim Crow and segregation. And I understand that emotional component. But that said, the question is, with Bostock, we were dealing with a super statute, and in academia, we have a special status for that. It's almost constitutional status. But how translatable do you think the Bostock rationale is to equal protection jurisprudence, first off? And assuming the worst, assuming that there's a full overlap between sex and gender in equal protection jurisprudence, importing the Bostock logic to just an equal protection challenge against some sort of government regulation in public school sports. Why is there concern on both sides here, or maybe it's a misperception of mine? Why is there so much concern about meeting intermediate scrutiny? It seems to me that a bunch of the more nuanced regulations against or just regulating participation of transgendered kids and adults in sports would easily meet intermediate scrutiny.
I don't think it would meet intermediate scrutiny because of the empirical data we've been talking about. Take the transgender bathroom. The government's going to have to show a governmental interest. And if the government can't present empirical data that what they're concerned about regarding student privacy is actually occurring, and I'm not saying it doesn't occur. It obviously occurs. We've heard enough anecdotal evidence to know it occurs. But it doesn't occur at nearly the rate that transgender individuals have feeling of harassed and discriminated against in their bathrooms. So I think that there would be an issue of being able to meet that significant governmental interest. So it would be problematic to pigeonhole it there. Once again, this is a problem that there's no right solution. There's no easy solution. This is going to be in our jurisprudence for decades to come. And I would like to, I'd ask Nancy this question too, because I don't see a solution. I don't see a solution that would make, equality in women's sports perfect while also protecting transgender rights. It's a zero-sum game. If we're going to, so I defer to Nancy.
It's a double hand race.
Yeah. So, we've been really focused on that one. And that is not part of the Bostock analysis, right? The first question is you have to have some boundaries around the girls and women's categories and making sure that it's actually for females. And then the second question is, right, is exactly what you brought up. Okay, well, how do we include? And swimming is uniquely sex integrated. So swimming and track and field, those two sports we work out together. I was never in my entire life on a women's team. I was only on co-ed teams. So we were in the same lane. We lifted weight for weight. We spotted each other. We stretched each other. We traveled together. As far as Leah Thomas's life pre-transition and post-transition, it was the same teammates, same coach, same training, same everything. So the only part that of being part of the sport, right? Remember I was talking about 100 years ago, we did this wonderful thing. The only difference is, where does the person compete? And surely there are ways that we can come up with to be able to allow transgender athletes to be able to compete meaningfully that don't blow up the women's category. So a lot of different things have been proposed. Right now, what the left is saying, my peeps, is that it should be full inclusion and there should be nothing else. And what we say is, most good swimming pools are 10 lanes and 8 lanes compete. So possibly having somebody in lane 9, possibly include, as the numbers grow, having typically it's women, men, and then, right, you could have transgender athletes. Sometimes you'll include people with different abilities, people who are amputees or whatnot. So there are definitely ways to do it, but the social construct of sport, which is 95% of sport, unless you're talking about a safety issue, swimming, we don't have a safety issue. In basketball and soccer and lacrosse and what others, rugby, right? There is a major safety issue. Males, I should say, are 7 inches taller. They weigh 20-30% more. So when you have just physics, mass force coming together, particularly the risk of concussions when you have transgender athletes, so they may not be able to participate together. But certainly the social construct of sport we should be looking at. But there are other ways, right? But we have to be able to come together. And right now, we're having a hard time getting the left to even get over to this other conversation, because what they consider is that it's othering. It is, right? It's making somebody feel different, and I agree that trans women are women, but I also think that women are women. And when I was part of the discussions back 12 years ago, when the NCAA was coming up with the rules, and what we were told is that 1 year of gender affirming hormones, somebody was going to move laterally. So if they were ranked 500th, they would move to the 500th place in the women's category. We now know that that's not true. And we know even from Leah's performances that that's not true. She did not move laterally. And right now, nobody is talking about trans men, so female bodies who transition, and where do they compete in sports? Because the minute they go on to testosterone, they're excluded from the women's category, and they will never be competitive with the men. So I competed against the East Germans for most of my career. I would not have won gold medals in the 1984 Olympics if the East Germans had been allowed to compete against me. When the wall came down, we know from the Stasi files that they were absolutely doping to the gills. And it only made them about 1 or 2% faster than we were, as opposed to 10%. They don't, female bodies that transition don't get anywhere near male bodies. So, right, so you have to be thinking about this, a position on how is it that we allow transgender people to be able to compete, but it has to be a both sides things. It cannot just be about women being kind and, here you go. It's okay. It doesn't make any difference. You're not winning everything. It's so insulting. Please don't say that. 60% of girls and boys play some form of high school sports, and they're able to do it because we sex segregate. And you ask anybody, I've looked at a lot of resumes in my life, and what people's sports accomplishments are usually up front and center.
And can I just real quick, I want to hit the equal protection thing, because I do think that is one of the things we ought to be worried about. With Bostock, you're dealing with Title VII. There's carve-outs, as Gorsuch recognized, for religious institutions, for bona fide occupational qualifications. Same thing in Title IX. Many of us here may have gone to religious undergrad or colleges or things like that. You put the Bostock reasoning in equal protection. What does that mean for religious institutions? What does it mean for a lot of the things? Whereas, at least legislatively, we can have those carve-outs. We can have those discussions. I also do worry, is this going to only stop at intermediate scrutiny? Or are you going to find some courts say, no, let's bump it up to strict scrutiny? And I think that is part of the concern with taking that approach. So I do worry about Bostock creeping over into equal protection.
Well, if any court tries to get this to strict scrutiny, we'll file amici with you on that
All right.
one. That's completely unworkable. And Nancy, I appreciate the comments, but I have in my profession have never seen sports achievements on a resume when I look at lawyers. And I was never an athlete. I'm sure you would whoop me in a swim race right now. I was never an athlete. I never joined any high school teams. I was always the statistician. But it was never so it's hard for me to understand that side of the argument. I've just never been there. My being able to get a medal in a sport that I was never competitive was never in my mind. So it's nice to hear from the other side, because I've never thought of it like that. I've never thought about the competitive drive, the competitive nature. To me, it's always, if you get 7th or 8th, that's fine. If you got 7th or 8th, and then you move on, because it's not something I ever did as a child. I was the debater. I was the national champion debater. That was my pride. And it didn't matter. It didn't matter if I was competing against men or women.
Right, and I bet that win is on your CV, that you were a national champion. That is very impressive. No. And similarly, women's sports, that's also, trust me, it is on their CV. I'm in like these two worlds. In one place, I'm full on in the sports world. One leg is over here. This other world is a civil rights world with people that I've worked with all my life. Women athletes have raised so much money for liberal groups, and to see them throw women's sports under the bus is painful. It is, right? So, because two different places. But I will say that one thing I hope everybody here is thinking about is, I have somebody in my life, in my family, who's transgender, and when I think of the Obama regulations and how they helped my family member, and what would have happened if they hadn't had gender affirming hormones, I cannot imagine. And by the way, I have permission to say that. And I always speak sort of wanting to be kind and find places for transgender people to be able to be successful, to be able to win. But at the same time, we do need to draw boundaries around the girls and women's category.
Well, thank y'all so much. Unfortunately, we have to call it for time to stay on schedule. But Matt, Jason, Nancy, this has been really, really interesting, and I can't thank you enough for your time. And I'm happy to be part of it.